I'm the Communications Coordinator here at the South African Human Rights Commission, and we welcome you to the first of many monthly media briefings that we will be hosting. Now, just to give you a bit of a context, of course, as the South African Human Rights Commission, we have a constitutional responsibility, a constitutional imperative in terms of Section 184, not only to protect and to monitor the attainment of human rights, but also to promote human rights and a culture of human rights within South Africa. And this is an opportunity for us to then proactively bring you news and developments within the Commission of the work that we are doing, things that are still in progress, and updates on issues that the general public and yourself as the media may not be aware of. So this gives us an opportunity to bring this to you proactively, for us to then use this as an opportunity to actually share the news with you. And so, as I mentioned, this is the first of these monthly media briefings that we will be hosting. And for all members of the media and the press, respectively, that have joined us, good afternoon to you, and thank you for joining us yet again. I think it is key and important that we're able to deliver this message through the use of popular mainstream media. Of course, these media briefings are going to be led both by our chairperson, that's Advocate Bongani Majola, as well as our deputy chairperson, Fatima Chauhan. And the relevant provincial managers have been called upon to then, in turn, assist with relevant questions that you may have in regard to the work that they're doing, as well as part of the various updates that we are providing. And today we are joined by Eric Wakanyama. He is the provincial manager for Mpumalanga province. We are also going to be joined by Victor Mabidula, who is the provincial manager for Limpopo province, Boang Jones, who is the provincial manager for Gauteng province, as well as Lloyd Lotz, who is the provincial manager for KwaZulu-Natal. And as aforementioned, this briefing will be led by the chairperson, Advocate Bongani Majola, as well as the deputy chairperson, Fatima Chauhan. So what's going to happen is that we have three broad areas that we will be focusing on. I'm not going to go into too much detail because I believe that the deputy chair as well as the chairperson will be taking us through that. But first and foremost, we will be looking at concerns related to certain local government service delivery failures and the impact on human rights, followed by important and recent freedom of expression and hate speech matters. As you know, something that the Commission has to deal with on a regular basis, as well as the Commission's briefing to the Parliamentary Portfolio Committee for Justice. So those are the three main areas that we will be focusing on. There are sections or subdivisions of those particular sections that the deputy chair as well as the chairperson will be going into a little more detail on. And then for the last half an hour of this particular briefing, that's when we open up for an opportunity for you as members of the media to pose your questions, and then obviously to proceed from that point forward. I just wanted to highlight during that particular period or throughout the course of this briefing, if I can just ask that you keep yourself on mute and keep your camera off until such time that you speak. During the half an hour for questions from the media, what we will then do is ensure that you are able to switch on your camera and pose your questions as needed. We'll take a round of 3 questions, give an opportunity for responses, and then take another round of 3 questions until such time that we either run out of questions, alternatively, that the time expires. That is it from me. With that, I call upon the chairperson of the Commission, Advocate Bongani Majola. Good morning to you, Chairperson. The floor is yours.
Good morning, Gashwal. Good morning to our colleagues in the Commission, but more importantly, good morning to the members, the ladies and gentlemen of the media. We are very grateful that you are giving us the opportunity to, through you, brief South Africa about the work that the Commission is continuing to do. And we hope that the partnership is going to grow from now on. As you may know, the mandate of the Human Rights Commission is the broadest of the human rights mandates of all Chapter 9 institutions that are established under the Constitution. In terms of its constitutional mandate, the Commission is thus responsible for the protection, the promotion, and the monitoring of the observance of all the rights that are outlined in the Bill of Rights. The Commission has power to, among other things, respond to complaints in various ways, including litigation, mediation, and investigation. It can pursue and investigate alleged human rights violations also on its own accord. At any given time, we are dealing with various and often complex issues that arise from all of the rights that are in the Bill of Rights. This media briefing, as all others to follow it, will focus on specific issues that the Commission deems relevant and of particular importance to report on at this time. We would like to focus specifically on the concerns related to certain local government service delivery failures and their impact on human rights, number one. Number two, on the important recent freedom of expression and hate speech matters. And then number three, on our obligation to report to the National Assembly through the Parliamentary Portfolio Committee on Justice and Correctional Services. I will be dealing with some of these issues, and then my colleague, the Deputy Chairperson, will deal also with the others. So let me deal with the concerns relating to certain local government service delivery failures. It is important to bear in mind that the Constitution imposes the duty on the state to respect, protect, promote, and fulfill the rights in the Bill of Rights. On the other hand, the Constitution imposes the obligation on the Commission to promote respect for those rights and a culture of human rights, to promote the protection, development, and attainment of human rights, and also, importantly, to monitor and assess the observance of human rights in the country. The state's obligation includes the duty to fulfill and deliver on socio-economic rights stipulated within the Constitution, such as the right to have access to sufficient food and water, health care, social security, and housing, to mention a few. Of course, these are not the only rights that the state has a duty to fulfill, since the Constitution requires it to fulfill all rights in the Bill of Rights. The state in this context will refer to all organs of state that make up the state, including local government. The Commission must always bear in mind that the duty of the state to fulfill socio-economic rights that are mentioned above depends on the availability of resources and reasonable measures that it takes to achieve their progressive realization. In relation to local government, the fulfillment of these rights requires service delivery at a local level. And this is where the Commission continues with its monitoring obligation. The Commission notes and is concerned by the number of complaints it receives from individuals and community each year in relation to the lack of service delivery. Complaints include the lack of access to housing, water and sanitation, the lack of an environment that is not harmful to people's health and well-being, and many other deficiencies. So for the purposes of this briefing, the Commission will provide an update on three important matters it is dealing with in relation to service delivery. And these are the current hearing in the Mpumalanga province on service delivery, progress in respect of the inquiry into water and sanitation in the city of Tshwane, and the Pietermaritzburg High Court finding on the Msunduzi municipality. On the hearing in Mpumalanga, the Mpumalanga Provincial Office has received and investigated service delivery complaints against various local municipalities for a number of years, and there are many of them. The issues raised in the various complaints include the failure by municipalities to provide water and housing, issues of sewage spillages into people's properties and even into people's houses, the sewage treatment challenges, electricity outages, the non-collection of refuse, as well as potholes on the roads. The fact that the number of complaints are not going down and recur each year suggests a deterioration of capacity to meet the needs of communities in many of these local municipalities. Various reasons, including financial and human resource constraints and non-payment for services by residents, have been proffered for the apparent deterioration of service delivery within these municipalities in Mpumalanga and also elsewhere. Notwithstanding the identification of these challenges year on year, little has been done in many municipalities to address them in a meaningful way. So in order to investigate these challenges, the Commission has therefore decided to embark on an inquiry at a systemic level into the state of service delivery within 12 of the local municipalities in Mpumalanga. The inquiry commenced already on Monday this week, 27 September, at the Ehlanzeni Disaster Management Center in Bombela. It involves Commissioner Ntuli and Commissioner Jonas Sibanyoni and the provincial manager of our Mpumalanga office, Mr. Eric Mukonyama. We expect that the panel hearings will be concluded by Friday, 1st October 2021. And the objectives of the inquiry are to, among others, assess the state of service delivery within local municipalities in Mpumalanga from a multi-stakeholder perspective and explore solutions to the identified challenges. This with a view to ultimately making findings, recommendations, and directives aimed at addressing the identified and recurring service delivery challenges. The inquiry is being live streamed on the Commission's homepage and social media platforms such as Facebook and Twitter. There will also be daily exhibitions at the venue of the hearings to promote the work of the Commission. A media briefing on the hearing at Mpumalanga will take place on Friday from 12:30 to 13:30 at the Ehlanzeni Disaster Management Center. So the second report I'd like to make is on the progress into the inquiry into water and sanitation management in the city of Tshwane. On 22 March 2018, the South African Human Rights Commission received a complaint from a Mr. Tumelo Koiteng, a resident of Hammanskraal. In the complaint, he alleged that the water supplied to the community of Hammanskraal had a strange color, it smelled badly, and was contaminated as a result of pollution emanating from the water treatment plants. In order to test the veracity of this complaint, the Commission conducted an inspection in loco on 17 July 2018 at the Rooiwal Water Treatment Works and at the Themba Water Treatment Works. The Commission was made to understand that the Themba Water Treatment Plant is the major water source in the Greater Temba region. So many people depend on it. The following was observed. First, the water pollution challenges were affecting the drinking water systems at the Temba waste treatment works, which sits downstream of the Rooiwal waste water treatment works, resulting in health risks to communities downstream. Secondly, the sludge treatment facility could not handle the amount of sludge that was being produced by the community. Thirdly, there was poor quality effluent, which did not comply with the permit conditions that the city has. And this was being discharged into the Abreast River. Fourth, key mechanical equipment essential for the optimum performance of the treatment process was not functional. 5, the city of Tshwane had commenced with the upgrading and extension of the Temba water treatment works. There was a need for emergency work at Rooiwal wastewater treatment works and the assessment of the farm water streams to determine the extent of the pollution thus far. So furthermore, the Commission learned from media reports and the Department of Water and Sanitation that the city of Tshwane has been accused of failing to comply with its legal obligations to protect the environment and prevent water pollution by ensuring and maintaining 3 other treatment plants under its jurisdiction. So since 2018 to date, various site meetings and inspections have been held and conducted, but no significant improvement is evident. Most actions agreed to by the city of Tshwane were not fully implemented or not implemented at all. The Commission's Gauteng Provincial Office undertook, therefore, an inquiry into the state of the wastewater treatment works in the jurisdiction of the city of Tshwane. The inquiry took place after the Commission received repeated complaints regarding the malfunctioning of the wastewater treatment facilities that was releasing untreated or partially treated sewage into the Abreast and Venus River and into the Roodeplaat and Leeuwkral dams within the jurisdiction of the city. It was decided that the inquiry should look at all wastewater treatment works within the city of Tshwane, which comprised Rooiwal, Klepgat, Baviaanspoort, and Sunderland Ridge wastewater treatment works. A number of ongoing engagements and site visits together with the city of Tshwane and the Department of Human Settlements, Water and Sanitation preceded this inquiry. The inquiry was held at the dam, at the Roodeplaat Dam. The city of Tshwane, the then Department of Human Settlements, Water and Sanitation, and the Department of Environment, Forestry and Fisheries were also invited to engage with and make submissions to the Commission regarding the condition, the management, and the status of the wastewater treatment works in the metropolitan area. This was to assess the effects of water and water waste treatment on the rivers and dams, determine the steps that were being taken or that would be taken to solve the problems identified, to correct the constitutional violation caused by the spillage of raw and untreated sewage into the rivers and dams, especially as it was polluting the freshwater sources within the city of Tshwane. Among the objectives of the inquiry, the Commission sought to explore the following. 1, whether the Department of Water and Sanitation has effectively performed its monitoring function or intervention by ensuring that the city of Tshwane, as the relevant water services authority in respect of the 4 treatment plants, complies with the prescribed standard. 2, whether the Department of Water and Sanitation has taken any legal steps, issued any notices, directives or convened meetings with the City of Tshwane with a view to rectifying or ameliorating the state of affairs. 3, whether the City of Tshwane has complied with any compliance notices and directives that were issued by the Department of Water and Sanitation. And finally, whether there has been structured, consistent, and careful engagement between the 3 spheres of government as required in Chapter 3 of the Constitution, which requires cooperative governance, regarding the deteriorating water quality in some parts of the city of Tshwane. People and animals who drink polluted water are vulnerable to illnesses such as cholera, hepatitis, and bilharzia. The elderly, the children, and those who are ill are even more at risk of adverse health conditions. The polluted water affects groundwater. The sewage pollution of dams and rivers especially means that the water can no longer be used for water sports and consequently as a tourist attraction. It therefore has a negative economic impact. It seems that the primary reason for the unacceptable levels of pollution is the failure of properly managing and maintaining existing wastewater treatment works in the city of Tshwane, and that this has gone on over a long period of time. Failures in management which have resulted in regression in standards of delivery include poor planning and implementation, as evidenced, among other things, by insufficient numbers of wastewater treatment plants to accommodate the growing population in the city of Tshwane. So these observations, among many others, along with the Commission's recommendations, will form part of the report that the Commission will soon be releasing. In terms of our procedures, however, the report and preliminary findings will be distributed to the affected organs of state, and they will be able to make further submissions, after which the Commission will then finalize and release its report, which will be containing its recommendations, findings, and so on. The Commission will alert the media through a media alert once the report is uploaded on the Commission's website.
Thank you. I take it that up next is going to be the Deputy Chair. Have you concluded yet? Or?
Yes, I have concluded. Yes, thank you.
Thank you for that, Chairperson. With that, we call upon the Deputy Chair, Fatima Chauhan. Thank
you. Thank you very much, Gashwal, and good afternoon to everybody present. The matter now concerns the New England Road landfill operated by the Msunduzi municipality. As you may know, the Commission instituted action in the Pietermaritzburg High Court against the Msunduzi municipality in February of 2021. In June 2021, the High Court found the Msunduzi municipality in breach of its obligations relating to the operation and management of the New England Road landfill site. We have provided the case reference for members of the media on the media statement. The Commission has welcomed the judgment handed down by Judge Rishi Sigobin, as the landfill site has been adversely affecting the air quality, environment, and security of the residents of surrounding areas for many years now. Members of the media and colleagues will remember that in July 2020, a major fire broke out at the landfill, which took over a week to put out. The fire affected the area and surrounds to such an extent that people evacuated the area due to the noxious air, and the N3 highway had to be shut due to poor visibility. This fire occurred during the COVID-19 pandemic, which, as we all know, results in shortness of breath in those affected by the virus. Heavy smoke, toxic and carcinogenic gases continued to be produced at least 4 days after the fire was extinguished. Various other challenges have also plagued the landfill site over the years. These have contributed and enabled the sporadic outbreak of fires and the emission of strong toxic fumes, as the types of waste coming into the landfill has not been regulated by the municipality. This poses severe threats to the sustainability of the environment and to the health and well-being of residents in both the local and surrounding communities. The two-pronged court order issued out of the Pietermaritzburg High Court included a declarator as well as a structural interdict as per the initial relief sought by the Commission. In terms of the declarator, the court found the municipality to be in breach of the revised compliance notice and the variation waste management license that was issued to it by the Department of Economic Development, Tourism and Environmental Affairs of KZN, which department was also the second respondent in the matter. The court further found the municipality to be in breach of Section 24 of the Constitution and Sections 20B, 31, L4, 28(1) and 3 of the National Environmental Management Act. In addition, the municipality was also found in breach of the National Water Act of 1998, as well as its obligations in terms of international law. In terms of the structural interdict, the municipality has been ordered to file a detailed and comprehensive action plan with the court within 1 month of the date of the court order. The municipality is thereafter to file monthly reports with the court indicating its progress in implementing the plan of action. The parties to the action, including the Human Rights Commission, is entitled to comment on both the action plan and monthly reports filed by the municipality. The municipality was also put on terms to discharge its duty of care and remediation of the environment in terms of the NEMA Act. Since the judgment, the municipality submitted an action plan, a draft action plan to the court in August 2021. This action plan, however, set no deadlines for the key targets that they've identified to enable measurement of progress. The court order stipulated that the KwaZulu-Natal Provincial Department of Economic Development, Tourism and Environmental Affairs has to approve the municipality's action plan. The department has not done so, as they too appear to share the Commission's concerns relating to the action plan presented by the municipality. We understand that the two spheres of government are engaged in dialogue about the various concerns of the department. The Commission, through its KZN office, has sought a meeting with the department to discuss the status of their engagement. To date, the action plan has not been updated. The Commission therefore reserves our rights to return to court to seek a contempt of court order should the need arise. Ultimately, and on behalf of the residents of Umsunduzi and in particular Pietermaritzburg, we seek compliance with the conditions on the landfill license that allows the municipality to manage the landfill at New England Road. We would like to see, for instance, the regulation of the types of waste allowed to be dumped there. For example, they should not be toxic matter such as harmful chemicals. We also would want the municipality to prevent leaching of the waste into water resources, as this landfill is located within the water table of the Umsunduzi River. We finally would like to ensure that the site is managed so as to restrict access and prevent fires and other hazards. South Africa's waste policy and legislation is now underpinned by the desire to entrench the waste hierarchy approach as part of an integrated waste management strategy. Waste hierarchy seeks to reverse the damaging environmental impact of landfills, which pose potentially dangerous health and safety risks and which potentially leach into groundwater sources or nearby rivers. Under this strategy, municipalities should begin developing policies around cleaner production by industries and businesses as a proactive measure to prevent excessive waste production. Next, municipalities should incorporate a recycling program and ensure that there is treatment of waste, especially industrial waste, and in the final instance, use landfills. It appears that this is not the approach of the Msunduzi municipality, which appears to rely solely on the New England Road landfill, which according to some studies has exceeded its lifespan. The Commission will continue to monitor and assess the municipality's progress in respect of the provisions of the court order. The Commission will further provide all necessary inputs, comments, and assistance that may be required to ensure that the rights of the citizens of Pietermaritzburg are protected as provided for by the Constitution. Moving on to the matter of freedom of expression and hate speech. Ladies and gentlemen, as you know, freedom of expression in our Constitution is not without its limits. When exercising one's right to freedom of expression, one should be circumspect and not transgress into the terrain of hate speech. Hate speech, apart from being a constitutional violation, also violates the Prevention of Unfair Discrimination Act. Recently, with the proliferation of numerous social media platforms, the Commission has found that many instances of hate speech are expressed through these very public and digital means. Violations of the right to freedom of expression through hate speech is one of the most common complaints brought to the Commission. We are of the view that members of the public in particular are generally not aware of the parameters, and to assist all South Africans to be in compliance with our Constitution and law, we are in the process of developing a social media compact or code, which could be used as a template for all other organizations and businesses, while being a learning tool for ordinary people in the country. This will address issues of hate speech and defamation, and we will hopefully launch this social compact or code in the very near future. Statements which violate the right to freedom of expression is usually directed at vulnerable groups on the basis of their race, class, nationality, sex, gender, or sexual orientation, gender identity or gender expression, along with many other distinguishing factors. The Commission also welcomes the clarity of the Constitutional Court, which provided for what constitutes hate speech in the matter of Kwelani versus the South African Human Rights Commission and another. This matter concerns an article that the late journalist, Mr. John Kwelani, had published in the Sunday Sun in 2008, entitled "Call Me Names, But Gay is Not Okay." In the article, Mr. Kwelani called upon politicians to amend the Constitution of the Republic of South Africa so as to remove the equal protection that the law offered to the LGBTQI community. Mr. Kwelani further compared homosexual people to animals and accused them of catalyzing the erosion of social values. The Commission received 350 complaints following the publication of the article, constituting the highest number of complaints received by the Commission relating to a single incident at the time. The Commission proceeded to institute proceedings in the Equality Court, which prompted Mr. Kwelani to challenge the constitutionality of Section 10 of the Promotion of Equality and Prevention of Unfair Discrimination Act for its broadness and its vagueness. This matter brought into sharp focus the boundaries of the right to freedom of expression. In a rich and nuanced judgment, the Constitutional Court clarified the components of hate speech under Section 10 of PEPUDA. Notably, the Constitutional Court found that the word hurtful should be removed from Section 10 because it limited the right to freedom of expression guaranteed in Section 16(1) of the Constitution. This is based on the reasoning that freedom of expression protects speech that might be merely offensive to a person. Additionally, the Constitutional Court confirmed that speech should be both harmful and incite hatred in order to be considered hate speech, and thereby constitute a violation of Section 10, which prohibits hate speech. In line with this, the Constitutional Court meaningfully engaged with what can be considered as harmful. It was found that the measure is objective to the extent that it can be reasonably determined that the speech causes harm, either psychological harm, physical harm, or societal harm to a person or to vulnerable groups. The Constitutional Court recognized that the LGBTQI community is a vulnerable group and agreed with the inclusion of sexual orientation in the list of prohibited grounds for the purpose of hate speech. Parliament now has 24 months to make the necessary amendments recommended by the court. Based on the above and the previous understanding of Section 10, the Constitutional Court found that Mr. Kwelani's abhorrent article constituted hate speech because it caused harm, and the incited hatred against the LGBTQI community was real. In the light of Mr. Kwelani's passing, the Constitutional Court held that the issuing of an apology and investigation by the police as ordered by the Equality Court was no longer appropriate. Nevertheless, the court confirmed the Equality Court's declaratory order that Mr. Kwelani's article constituted hate speech that vilified the LGBTQI community. Moreover, the court held that the Supreme Court of Appeal's cost order against the Commission was inappropriate and accordingly ordered that Mr. Kwelani's estate pay the Commission's costs. Section 10 of PEPUDA now reads as follows. Subject to the proviso in Section 12, no person may publish, propagate, advocate, or communicate words that are based on one or more of the prohibited grounds against any person that could reasonably be construed to demonstrate a clear intention to be harmful or to incite harm and to promote or propagate hatred. The Commission calls on every member of the South African society to desist from engaging in hate speech and to instead actively promote equality and social harmony in an endeavor to achieve the constitutional vision of a society based on human dignity, freedom, and equality. I move on to the next matter, which we have named the Tracy Zilla matter. The South African Human Rights Commission was alerted by media reports of a person, one Tracy Zilla, who posed on Twitter as a white female, pushing a racist and misogynistic viewpoint on Twitter. Our Limpopo Provincial Office instituted proceedings in the Louis Trichardt Magistrates Court to pursue the matter against Anthony Matumba in respect of harassment on the basis of gender. The respondent denies that he is Tracy Zilla. However, an expert witness has been obtained to assist the Limpopo Provincial Office to prove otherwise. The Limpopo office requested the account details of Tracy Zilla from Twitter. After a lengthy standoff with the multinational social media platform, the Limpopo Provincial Office obtained a subpoena from the Equality Court, which was served on Twitter, and the account details were subsequently provided to the Commission. The matter is still the subject of litigation and is poised to be argued in the Magistrates Court on the 6th, 7th, and 8th of October 2021, and the Commission has been joined by Media Monitoring Africa as amicus curiae in this matter. Finally, the South African Human Rights Commission, like all public institutions, is accountable to Parliament as well as the public. The Commission is held to account by elected representatives of our national legislature, and we therefore regularly report to the Parliamentary Portfolio Committee on Justice and Constitutional Development. The Commission is due to report to the Portfolio Committee once more during October of 2021. The Commission will be providing an update in regard to its performance in the execution of its constitutional mandate, as well as its budgetary management and spend. It is essential, we believe, that the media cover these briefings as it brings the public closer to understanding and viewing the entirety of the Commission's workings. And that basically concludes my part of this statement. Thank you very much.
Could I thank you for that, Deputy Chair? I'm sorry, I was just having some difficulty switching my camera back on. Thank you for your input, as well as the input from the chairperson. Unfortunately, while you were speaking throughout the proceedings, starting with chairperson, we seem to have picked up technical difficulties, especially with external participants being members of the media, having access to this particular session. So that leaves us with the unfortunate situation of having to then end the briefing at this stage, along with the recording. What we will be doing subsequent to this is that we will be posting this recording on our YouTube page, and once we have the link for the recording on our YouTube page, I will then send out another media alert, for this particular briefing. And with that, what we will then also do is I will then obviously facilitate and ensure that the questions reach the chairperson, the deputy chairperson, as well as the provincial managers that set aside their time to join us this afternoon. I do apologize for the inconvenience. Unfortunately, for some reason, the system is preventing external participants from joining this live event, and that is why we're faced with the unfortunate situation of having to end it here and then take media queries post this particular event. We will obviously endeavor after this to ensure that this does not happen again, that we have an opportunity for people to interact on a live basis with the Commission in real time as opposed to that. So with that, I will ask then that we end the recording at this stage. Kiba, if you don't mind just ending the recording, and thereby we'll be able to immediately then take this and then put it on to our web page, YouTube page. Thank you so much for your participation.